Hello and welcome to the Minimum Competence episode for Friday, May 2nd, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, Justice Jackson warning of judicial intimidation, Trump restarting the bench wars, and Google fighting to keep its ad tech empire intact. Let's remember, sooner or later, everyone sits down to a banquet of consequences and stupidity brings the appetizers. And read today's legal news. On May 2nd, 1939, Louisiana adopted its current state constitution, known as the Louisiana Constitution of 1921, which at the time marked a significant overhaul of state governance. Though originally adopted in 1921, it underwent critical amendments and re-ratification processes culminating on this date to reflect broader federal constitutional principles, especially concerning civil rights and governance reforms. This version would go on to become one of the most amended constitutions in the U.S., highlighting Louisiana's complex political and legal environment, particularly around issues of race, voting, and economic regulation. On the federal level, on May 2nd, 1957, Senator Joseph McCarthy died, signaling the end of one of the most controversial chapters in American legal and political history. McCarthy had become the face of post-war Red Scare, using Senate hearings and investigations to accuse numerous government officials and private citizens of communist sympathies without substantial evidence. His tactics led to the coining of the term McCarthyism, representing the broader trend of reckless accusations without due process, a violation of basic legal protections. His downfall began with the 1954 Army-McCarthy hearings, where his aggressive questioning was televised, turning public opinion sharply against him. Also on May 2nd, 1963, during the Birmingham campaign, hundreds of African-American children and teenagers marched in Birmingham, Alabama as part of a civil rights strategy to provoke mass arrests and draw national attention to segregation. The police response, using dogs and fire hoses on peaceful demonstrators, shocked the nation and galvanized support for federal civil rights legislation. These events laid crucial groundwork for the Civil Rights Act of 1964, which fundamentally altered American legal frameworks surrounding discrimination. Justice Ketanji Brown Jackson, never one to sugarcoat institutional danger, pulled no punches in a recent address where she warned that political attacks on the judiciary, particularly from Donald Trump and his orbit, aren't just angry outbursts, they're strategic. Not random, she emphasized, but seemingly calculated to chill the bench and warp the public's view of judicial independence. Speaking in Puerto Rico at a judges' conference, she framed the threats and harassment against judges as not merely inappropriate, but corrosive to democracy itself, an erosion of the rule of law masquerading as political speech. While Jackson didn't name Trump directly, a nod perhaps to judicial decorum, she acknowledged, quote, the elephant in the room. That elephant has been stomping around the judiciary for years, from defying court orders to demanding impeachments of judges who don't rule his way. Chief Justice John Roberts, no firebrand liberal, has already rebuked Trump this year for trying to undermine judicial authority. Jackson's remarks, which reportedly drew a standing ovation, echo deeper concerns among legal scholars about an impending constitutional crisis fueled by executive overreach and coordinated judicial delegitimization. With a 6-3 conservative majority still holding firm on the Supreme Court, her comments are more than ideological protest. They're a pointed reminder that the judiciary's legitimacy isn't just under rhetorical attack, it's being targeted as a political obstacle. And in Jackson's view, the stakes couldn't be higher. Donald Trump's judicial conveyor belt of bozos is up and running again. Yesterday, he announced his first federal judicial nominee since retaking the White House, Whitney Hermendorfer, a conservative legal operative from Tennessee who's clerked for 3 sitting Supreme Court justices and currently works under the state's Republican Attorney General. If confirmed, she'll take a seat on the 6th U.S. Circuit Court of Appeals, a vacancy that lingered after Biden's nominee stalled amid GOP opposition from Tennessee's own senators. Trump's post on Truth Social didn't mince words. Hermendorfer is a, quote, fighter, a term that doubles as both a branding strategy and a judicial philosophy. Her resume backs that up. She's defended Tennessee's abortion ban and fought Biden-era protections for transgender students. Translation, she's been in the legal trenches of the culture war and emerged as a reliable soldier for the right. This nomination is the opening salvo in what could be a new wave of over 100 judicial appointments in Trump's second term, offering him another shot at reshaping the federal bench after appointing 234 judges, including 3 Supreme Court justices, during his first term. Hermendorfer is stepping into a seat vacated by Judge Jane Stranch, herself an Obama appointee, whose intended successor under Biden, Carla Campbell, never got her Senate vote thanks to a post-election deal between Democrats and Republicans to fast-track some trial court nominees at the cost of 4 appellate picks. Great choice. The judicial arms race is back, and this time the Senate arithmetic and the vacancies left behind may tilt even harder in Trump's favor. Google's legal team is headed to federal court today to plead with Judge Leonie Brinkema not to yank apart its advertising tech empire. At stake is nothing short of the future architecture of online advertising. The DOJ is pushing to force Google to divest key parts of its Google Ad Manager, including the ad exchange and publisher ad server, core infrastructure for monetizing digital content. Think of it kind of as ripping out the plumbing from the internet's ad economy. Judge Brinkema has already ruled that Google unlawfully tied its ad server and ad exchange, leveraging its dominance in a way that stifled competition and hurt publishers. Not exactly a glowing endorsement of their market behavior. Still, Google insists a forced breakup isn't just excessive, it's legally unjustified. Their position is these tools do more than just hawk banner ads, and the DOJ's remedy would be a regulatory overreach. In the backdrop is another case in DC where the DOJ is toying with the idea of making Google sell Chrome, the browser, over its search dominance. Google clearly doesn't want a repeat of that nightmare here. So the message from Mountain View is clear. Let's talk tweaks, not torpedoes. But Brinkema has already signaled she sees systemic harm. Whether that translates into structural remedies or just more behavioral promises now depends on how persuasive Google's lawyers can be without sounding like they're defending a monopoly. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment and can leave a rating or review on your podcast player, we'd sure appreciate it. And if you know someone that might be interested in the story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter form. We'll see you back here on Monday, and until then, note, we like to close out the week of shows with a featured musical piece. That will make these Friday episodes seem especially long. We hope you'll stick it out and enjoy the featured piece, but if music, and specifically classical music, isn't your bag, we get it. Our mouth sounds unrelated to the week's closing music ends here. This week's closing theme brings us into the fiery imagination of Hector Berlioz, the 19th century French composer who lived as intensely as he wrote. Berlioz was a romantic through and through, equal parts visionary, dramatist, and eccentric. His music defied convention, his orchestration exploded boundaries, and his literary obsession with Goethe's Faust gave rise to one of his most enigmatic and powerful works, La Damnation de Faust, The Damnation of Faust, completed in 1846. Not quite an opera, not quite a cantata, Berlioz called it a dramatic legend, a hybrid form that suited his unconventional style and theatrical flair. Drawing from Gerard de Nerval's French translation of Faust, the work traces the tortured scholar's tragic arc, from existential despair to enchanted pastoral scenes to infernal damnation, all wrapped in Berlioz's vivid orchestral color. Its fourth part, the Ride to the Abyss and Pandemonium, is especially striking, a blazing descent into hell that's often performed independently, particularly around Walpurgis Night on April 30th and May 1st, when tales of witches' sabbaths and demonic revels echo the scene's imagery. At its premiere, The Damnation of Faust baffled audiences and bombed commercially, though it has since been recognized as one of Berlioz's masterpieces, showcasing his flair for narrative, his taste for the macabre, and his unmatched orchestral daring. It remains a high watermark for musical storytelling without staging, and an apt closer for a week shadowed by ambition, unrest, and devilish bargains. Without further ado, The Damnation of Faust by Hector Berlioz. Enjoy.